Hi, my name is Arati Ganeshan and I'm a journalist at Medianama. I'm here today with our editor Nikhil Baba to talk about the current challenges against the fact check amendment being heard at the Bombay High Court. A couple of weeks ago, the government released an amendment to the IT Rules 2021, which essentially outlawed platforms from hosting information that's been identified as fake, false, or misleading by a government appointed fact check unit. The catch here is that this information would be related solely to the Union of India's business, or basically government related information. So, what people were concerned about after that is essentially was that the government was giving itself powers to fact check information about itself during a politically contested election year. Shortly after the amendment was released, we saw challenges filed almost immediately at the Bombay High Court. The first was filed by the comedian Mr. Kunal Kamra and spoke a lot about how the government was giving itself powers to determine what was true and false and the consequences of that. The second came in from the Editors Guild of India and looked at the consequences of how the amendment would impact not just free speech in India, but also free press and a journalist's right to fact check information that comes in from the government. Another petition by the Association of Indian Magazines looks at similar arguments, particularly noting about how this will impact free speech and democracy in India. And finally, we have an intervening application that came in recently where Mr. Arvind Dattar, representing the petitioners in front of the court, essentially spoke a lot about the ambiguity and definitional issues with the rules that basically make it very hard to understand what the government is trying to do. So we've seen these issues play out in the petitions and in court over the last 3 weeks. And now I'd like to hand it over to Nikhil. Do you have any questions, comments, or concerns over the proposal that have come to mind over the last few months?
So, Aarti, one of the things that I was wondering about was it's very clear that these rules are unconstitutional in the sense that effectively the IT Act doesn't allow the creation of definitions, and there are multiple cases related to the IT Act to the IT Act rules in the Supreme Court.
Right.
But what we've seen with Aadhaar in the past, there were several cases challenging Aadhaar in the Supreme Court, and one of the key arguments was that Aadhaar is not backed by law. So what the government of India did then was that they one fine Thursday night at 9 p.m. they listed the Aadhaar bill for tabling the next day, and they passed it in the Lok Sabha on a Friday, where there are times when many MPs go home to their constituencies for the weekend, because Friday is typically a private member's bill day. So with not a full strength Lok Sabha in play, they passed it as a money bill. And so effectively one key argument was lost in the sense from the case in the Supreme Court, because there was then a law legitimizing Aadhaar. I'm just curious about, we've been hearing about the Digital India Act, and it's very likely that when the Digital India Act does come up, rules legitimizing this fact-checking unit, just like rules legitimizing, for example, breaking into an encryption with the IT rules, this entire set of criminal liability for the official of a social media company, the proactive monitoring of content, a bunch of these issues, and also, of course, regulation of news media, even though the IT Act doesn't allow them to do it. All of these issues will probably be legitimized through the Digital India Act.
Right.
I'm just curious about whether, in your opinion, are the arguments that are being made in court by the petitioners, are they strong enough if you ignore the fact that they are also not backed by law?
I would say absolutely. At a most principle-based foundational level, one would hope that just the fact that this impacts free speech and free press in India is enough. I think it's obvious the ways in which this does that, so I'm not going to go into that too much. At a principle-based level, one would hope that that would be enough to just any kind of law that comes in and tries to unilaterally control what is true or false online about the government. Even if you set aside the principles-based discussion, I think there are fundamental issues with how the law has been framed, um, uh, which really prevent it from sort of being held in sort of any other form as well. So, for example, even if you're just looking at fake, false, or misleading and business of the central government, which is what this whole amendment is about, there is no actual definition of any of those terms in the IT rules themselves. And this is something the court has also repeatedly come back to during the hearings as well. Every single petitioner has come forth, pleaded for hours before the court. And despite that, the one thing the court comes back to each time is what are the definitions? Because it's hard for us to understand what you're challenging if we don't even know what the law is about in the first place. That brings me to the second point, which is that according to the petitioners, the government actually has clarified what it means by business of the government in its affidavit that was filed before the Bombay High Court. And it's referred to various constitutional provisions, such as, this is to do with executive action and all of that. But again, you can't clarify that in an affidavit and not clarify it in the law, which is what people will actually be reading. An affidavit is not public information or publicly disclosed. So, I mean, just the fact that we don't even know what the scope or boundary of information the union government can fact check itself is a problem for me. Um, there are also questions of proportionality, and we have a very detailed post on the hearings on Medianama if anyone's interested, of just the proportionality of this amendment, which have been raised by various petitioners. We already have, I believe, a misinformation clause in the IT rules as well. I think it's misleading information. Platforms cannot host misleading information as well. And we also have a grievance appellate committee where you can complain about, how a platform has dealt with a content takedown request or with a content takedown in general, and then appeal before a government appointed committee essentially to overturn or stay that ruling. So what a lot of the petitioners were saying is we already have this mechanism here. Why is the government coming in and saying for government appointed information alone, we need a separate sort of fast track route where we only have this one sort of executive fiat where you're taking down information? Why was this the best alternative? Why was what was there earlier not good enough? And I don't think, I mean, until the government argues, we really don't know why the government thought this was necessary at all in the first place. So, I mean, that's one part of it. And again, I don't want to go into this and potentially misrepresent anyone, but there are enough arguments that have been made in the case as well that this also violates various principles of natural justice as well, because as the court has observed, as various petitioners have observed, the platform is not necessarily specifically and explicitly given an opportunity to be heard before it takes down the content or after it receives the notice, rather. So even if you're just looking at the natural justice principles, which are required when you're sort of looking at cases like this, they're not really present in the amendment as well. Now, the question is, would the government actually rectify all of these infirmities, perhaps in a Digital India Act, under rules of the Digital India Act? Maybe it would look at these pleadings as a sort of helpful guide of what it should be correcting and what it shouldn't be correcting. I don't know. But I don't think the law as it stands satisfies or answers enough key constitutional questions. So I don't think it would stand if brought in another form.
Yeah, Atit, if you go back to the arguments that were being made by the government prior to or during the consultation process,
Mhm.
The argument they were making was that the government is the best um, judge of information about itself,
Right,
and that they have access to more information
right,
about themselves than the general public does,
right,
or the media does when it is reporting on an issue. So they are in the best position uh,
right.
to correct that information. This sort of ignores a couple of things, right? Firstly, if the government has access to certain information that it is willing to put in the public domain to defend itself
Mm,
or to take down content, um, then in that case, it's important for them to make that information public in the first place.
right.
If there's certain claims that they're making that are being debunked that they want to take down, then they can't be, a judge in their own matter in the sense, right? They can't really adjudicate whether something is fake or not. That has to be left to a third party.
Right,
It's typically a judge.
right,
Um, the other thing is that you know, heading into an election year, um, this, along with the creation of a government accountability committee, along with expanding the scope of India's blocking rules, Section 69, to news publishers, which is what they've tried to do,
right,
is essentially a mechanism of becoming the arbiter of truth, which is something that is not the role of a government, at least. As we say in journalism, like uh, it's the inconvenient truth that matters most. It is the part that, like, um, everything that you want. It's I mean, uh, what you it's journalists should be reporting what people don't want reported.
right,
Everything else is a press release. So
right.
it almost looks like the government is trying to ensure that uh, you know information that is inconvenient to them gets taken down. The other thing is that because there is a stay order also in the news publishers case, they now can't impose Section 69 directly on the news publishers
Mm,
and censor their content.
right,
What they're doing is that they're using this mechanism to censor the same content on social media. And, to some extent, there is a precedence for this as well. The Singapore fake news law, for example, allowed an official from the government of Singapore to tell social media platforms to take down content. Um, we are heading into an election which is probably going to be a deep fake election with a vast amount of disinformation uh, being circulated. Um, in that sense, one, it's going to be difficult for platforms to discern what is disinformation and what is not. Um, but it's also going to be extremely tricky uh, for governments as more and more inconvenient information also comes out about them. So, who'd be a social media platform at this point in time?
absolutely. And I mean, even just to your point that the government says it's in the best position to fact check information on itself. And in many cases, I would say perhaps it is, nobody knows you better than you do. And I think that's exactly one of the arguments that was sort of raised off the cuff in court as well, is that in the same way a body corporate or a company or I can say, I'm the best, I know the most about myself. So why can't I have, my own executive fiat that, platforms cannot host information about me unless I say it's true or false. That same logic could be applied to anyone. And so another sort of argument that was raised, which was interesting on the same point, was essentially it's unfair, even in the current appellate process, to even use an argument like this. Because how is if a user doesn't have access to information that only the government has, if a grievance officer who's dealing with a complaint, say on the takedown of something, doesn't have access to that information, how exactly are they supposed to even challenge or appeal or decide on a complaint like this? Because it's simply just not in public circulation. So it's also a question of, setting a precedent like this makes it harder to actually move complaints through the pre-existing complaint system that you have in a certain way. And again, coming back to the thing of what you said, where typically courts are supposed to determine these issues, that's exactly what the petitioners have been saying. It's a total executive overreach, and this is typically a judicial function. And ironically, sort of in off the cuff statements while they've been discussing this issue, even the bench has observed that often courts, it's very hard to determine what is the truth. Like, is it possible for a unit that's appointed by a government to even have the power or the wherewithal to arrive at a very definitive understanding of something that's possibly philosophical and abstract and just hard to grasp in a certain sense. And I think that is sort of one of the biggest issues over there. And I was actually, on a separate note, wanting to ask you, since I know you've been involved and sort of heard Shreya Singhal happen blow by blow. Many people who in the proceedings have also argued that this sort of precedent of denying opportunities for platforms to be given a hearing before the government, not providing a notice with reasoned orders, all of these violate some of the principles that were set down in Shreya Singhal. back when Section 69A was upheld and Section 66A was struck down. So do you see any parallels there with that moment of time and this one as well?
No, I think one of the challenge, and I remember I walked out of court number one that time, and I was quite despondent about the fact that Section 69A hadn't been struck down.
Mm,
And the reasoning of the court was that, Justice Nariman had written that, it is understood that when the creator of that information is identifiable, they will at least be given a hearing
mm,
by the committee. So the what Section 79A was written down because it did not have enough checks and balances, and here the court seems to have thought that just because there is a government committee that's looking into this, there is a check and balance in place. But uh, very clearly, if you see in Section 69A, there is complete lack of transparency because of the rules. There is, from what we hear, on many orders that are sent out are essentially emergency orders, which means that they don't require a hearing before the ban order is issued. We don't know how often these orders are actually reviewed.
mm,
Um, and so, and then there's lack of accountability. The only time we've seen the 69A orders become public was when, not orders become public, but even information about 69A orders being issued to ban something has been with the Chinese apps ban. And then to some extent, I think Ministry of Information and Broadcasting also has announced the fact that it has banned certain YouTube channels.
right.
So, there is selective transparency there from the government and very convenient transparency there from the government, which is a problem. Um, if you want accountability, then there has to be a uniformity in that process. Users don't get heard when something gets taken down. The other thing is that just because a link has been shared on social media related to a news article, um, is it that every single post mentioning that is going to get blocked across the platform? Even a critique of that piece, will that also be blocked across the platform?
Mm,
How is this actually going to get operationalized is not very clear. And besides the fact that the government cannot be like a judge in its own matter.
absolutely. And I think just a final parting thought from me, especially, was these were arguments that were brought by Mr. Shadan Farasat, who is representing the Editors Guild of India. And sort of very eloquently, he spoke about ultimately what was Article 19, which protects free speech in India. What was it actually meant to protect? Is it just protecting speech in general, or is it protecting political speech? And according to Mr. Farasat, and that was sort of a theme that we saw across the board, it was to protect political speech. It was to protect against state interferences and control over speech. And so, especially as we're heading into this election year, you cannot underscore the importance of, attempts to dilute down the protections of Article 19 1A, because it's also in many ways an attempt to dilute the kind of political discussions that are critical during a year like this, the kind of dissent that is critical during a year like this. And also, as Mr. Farasat said, which I sort of thought about a lot afterwards, he was like, you can't actually get to the bottom of the truth without free speech. It's through free speech that you discuss, debate, argue, contradict each other, and then eventually you might get somewhere to like a semblance of what the truth or what reality is. So
In
what,
fact, Ati, just to add to that, let's not
yeah,
forget that the government has the most power in this equation, right?
absolutely.